Hello and welcome to talk number 3 in this series about how to present arguments before a legal audience. My name is Declan O'Dempsey, I'm a barrister at Cloisters Chambers. I want to talk about the use of generalisations. In short, try and avoid using generalisations if you can. If you do use a generalisation, then support it with accurate examples. Don't use just one single incident. So, for example, suppose the witness was inaccurate when giving evidence about X. You might want to say, well, nothing can be relied upon by the court, which comes out of the mouth of the witness. Well, your assertion that the witness was inaccurate in the evidence about X is unlikely to be persuasive if it's inaccurate in itself, or if it's a single instance of inaccuracy. A better way of formulating things might be to say that the witness gave inaccurate evidence about a particular issue, X, and say why the evidence was inaccurate. The witness also gave inaccurate evidence about issue Y, again, give the reasons why it was inaccurate, and Z, etc. Therefore, what the witness is saying about every other fact which is in dispute in the case should not be relied upon. Now, the latter way of formulating it is more likely to persuade a court that in general the witness is not truthful or reliable than the first way of putting it, which seeks to generalise from one instance of inaccuracy. If you are going to generalise, try using a representative group of examples. If there are obvious differences between the examples, the courts are unlikely to accept the generalisation that you're asking it to make. So, for example, you might want to say that my manager was always putting me down at work by criticising me. Look, he criticised me on 1, 2, 3, 4, and 5 occasions. Now, this won't be particularly persuasive if there was a proper basis for the criticism in the majority of those cases. Far better to accept that there were proper bases for criticisms on some occasions, but pointing out where there was simply no basis for criticism. Make sure you can deal with counterexamples, and if you can't, then restrict your generalisation. Don't generalise as much as you were planning on generalising. So, consider whether you need to generalise. Perhaps saying that on relevant matters the witness's evidence cannot be relied upon is better than saying that the witness can't be relied on for any information. Another method that people like to use to try and persuade is the use of statistics, but numbers don't bolster an argument by themselves. You might, for example, want to think about this example. The witness says, previously many of the defendant's branches didn't meet the needs of disabled people. 25% of disabled people now use the defendant's services, therefore the service standards are improving. If you think about that for a second, to show improvement, a comparison would be needed with the earlier state of affairs. So the mere use of statistics or percentages doesn't really tell you anything unless they're being used in a proper way. And sometimes people think that merely citing or referring to numbers gives their argument a greater air of authority. But statistics are only good as the source of the information that you've got. So ask the question if you're getting a statistic, and if you're going to employ a statistic before a court or tribunal, ask what the source of the information is, and ask whether or not it's representative. Another way that people argue is by analogy. Now, this is where you say A is B because it's like C, and C is often B. So, for example, a flying boat is like an airplane because it flies, and so therefore it should be classified as an airplane rather than a boat, although it floats. How do you go about constructing a analogy argument? Well, first of all, you make a claim about the thing said to be the analogy. So I might say, I claim the desk the court is using is mine by simply declaring that it's mine. Now this is like what the defendant's doing, claiming to own the property I left with the defendant for safekeeping. The defendant is simply declaring that it belongs to the defendant. Well, just as I can't get the desk by asserting it's mine, the defendant can't refuse to give me back my property by asserting that it's the defendant's. Are your examples similar in your analogy in a relevant way? So, for example, the assertion of ownership of property in the case of the court's desk and my bailed property. If you want to say that the analogy of your opponent doesn't prove anything, you need to show why the analogy is not good. So you need to ask yourself the question, what are the relevant dissimilarities? So, for example, a defendant might want to point to the fact that the court desk and the property in the defendant's possession are in very different circumstances. The defendant's not simply making an assertion of ownership. The property's been in the defendant's possession for a very long time, and they'd want to point to other circumstances as well. So in other words, they would say that the two situations are not properly comparable. In arguments in the courts in this country, judges do listen and indeed are bound to follow decisions of more senior courts and also, to a certain extent, other courts which have decided the same type of question earlier at the same level. There are ways of referring to legal authorities, but there's also a more general way in which we use authority in arguments. You can appeal to a reliable source and say, therefore, what that reliable source is saying is correct. The things you have to watch out for here are bias in the source, which indicates that it's not reliable, and also where, although the source may be reliable for the information, there's been an unreliable chain of information, so that somewhere between your source and you're receiving the information, there's a possibility that the information has become distorted. There are special rules in the courts for relying on expert evidence. In the case of a non-expert witness, so that's somebody who's giving evidence of the facts in the case, authority can come from the reliability of that witness. But the same principles should be looked at in each case. You look at the sources of information that the witness is relying on. Now, if you're preparing a statement for one of your witnesses, or if you're trying to refer to what a witness has said in your argument to the court, you will want to spell out the sources of the information that the witness relies on. Don't be vague, in other words. Why, the court will want to know, does your witness know what they're talking about? And this is why an independent witness is much more likely to persuade than somebody who's got a stake in the outcome, because they're more likely to be reliable. So the more independent the source is, the more authoritative it is likely to be when it makes an assertion of fact. Disinterested witnesses are more likely to persuade a court. So, what's the best source? Check whether your witnesses agree on a point or whether there's division between them. If there is division, that can be okay. You have to ask whether the division is significant or whether it's irrelevant to the issues in the case. Disagreement is okay and can indicate that the witnesses are telling the truth, because nobody will remember the same set of events in exactly the same way. It's dangerous to appeal to the internet. By the time you're making an argument, all the evidence should be before the court, so that's all the evidence on which you're going to rely. So it's a mistake to stand or sit there in front of the judge and say, well, you can find all this stuff out on the internet. No, better have the material there with you. If that means printing it off the internet, then do that. Now, I've said that you will have to rely, in some cases, on case law authority. There is a free source of case law for the UK, which is the Bailey website. Use it with care. You've got to make a careful search for relevant cases, and remember that courts are not going to be impressed with being given lots of irrelevant cases to read. So try and think what principles of law you think you're going to need to rely on, and then use those cases that show that the principles of law that you're relying on are the correct ones. Another aspect that you need to address in constructing an argument is what's called causation, so what caused what. Go back to the example of the person who's saying that their manager had it in for them. You could try and prove causation by referring to the fact that decisions by your manager were regularly associated with you being treated detrimentally. Therefore, you invite the court to conclude that the manager's decisions caused the detrimental treatment. Decisions by your manager may well not have been regularly associated with the detrimental treatment, and so the court may conclude that they didn't cause the treatment. However, this kind of mere association is generally insufficient to establish that one thing caused the other, because there may be explanations which are innocent ones for the association, or it may be just coincidence, or there may be underlying causes or an underlying cause. What you have to do is argue that your explanation for what caused what is the most likely explanation of the events, and you can do this by seeking to demonstrate the connections between the events and how they explain the events sensibly. So, for example, you might argue, well, yes, there was association of the decision by my manager and a detriment happening to me, but it's not just that there was association. There isn't any other explanation available except that my manager's decisions caused me the detriment that I suffered. You might want to point to additional facts that show causation. So, for example, as well as there being a regular association of managerial decisions and detriment to you, you can point to the fact that your manager was told, your manager said to his friend that he hated you when he was appointed, and since then every decision he's taken has caused you a problem. Or you might want to say there was association of the decision and the detriment and other explanations, but those other explanations are less likely than the one that you're putting forward. So, for example, your manager was told by his manager that overtime was to be restricted. So that accounts for why I got less than I did before, but it doesn't explain why I got none when others got some. The most likely explanation for the manager's decisions is that they were causing me not to get overtime when others did. And if we also know that he had stated that he hated you, then it's probably because he hated you.